Greetings and welcome to today's webinar on executive decision-making and liability for public health officials, brought to you by the Network for Public Health Law, the Partnership for Public Health Law, and the American Society of Law, Medicine, and Ethics. My name is Dave Clark. I'll be your host for today's event. Now, before we get started, there are just a couple of things I'd like you to know about. Concerning the audio, today's webinar is listen only. That means that you can hear us, but we can't hear you. But that doesn't mean that today's event won't be interactive. We will have a live Q&A session at the end of the webinar, and you can type your questions at any time into the Q&A panel. You don't have to wait till we get up to the Q&A session. You can type those questions at any time. The Q&A panel is located on the right side of your screen, and it can be toggled on and off by clicking the Q&A icon that you'll see at the top right of your screen. If you're on a Mac today, you'll probably see that icon on the bottom right of your screen. Now, this is important. In the Q&A panel, make sure that all panelists is selected from the drop-down menu. If it doesn't say all panelists, make sure to choose that option. That's the only way we can guarantee that your question will get sent to the right place, and our presenters today will be able to answer it. So if you have a question, before typing in that question, make sure that it says all panelists in the drop-down menu. And by the way, you can also use the Q&A panel to communicate with me. If you're having any technical problems, including audio issues, just let me know what the problem is, and I'll help you out. We're really interested today in all of your thoughts and questions on this topic, so be sure to get all of them into the Q&A panel, and we'll try to answer as many of your questions today as we can, I promise. All right, I think that's everything you need to know for today. Let's get started with today's presentation on executive decision-making and liability for public health officials. Our moderator today is Jason Coates, a health policy analyst at the American Public Health Association. Jason conducts research on the Affordable Care Act, health system reform, public health law, and environmental health. He's delivered presentations on the ACA to professional and academic audiences, and he's currently developing resources to inform school-based health centers on the process of health reform. Before the American Public Health Association, Jason was a public policy associate at the National Hispanic Council on Aging, where he researched, wrote, and advocated for policies to improve the health and economic security of Hispanic older adults, their families, and caregivers. He's a graduate of George Washington University Law School and the University of Chicago. Jason will be leading us through the rest of today's webinar as our moderator. So, Jason, over to you.
Thanks, Dave. So, I am Jason Coates, Policy Analyst at the American Public Health Association. Thank you for joining today's webinar. Today's webinar is sponsored by the Network for Public Health Law and the Partnership for Public Health Law, which is a coalition of the American Public Health Association, the Association of State and Territorial Health Officials, the National Association of County and City Health Officials, and the National Association of Local Boards of Health. So with this webinar, our goal is to describe some of the issues like use of discretion, different types of immunity and criminal liability that public officials may consider in decision-making process. So presenters will describe how to document the decision-making process, when sovereign immunity applies and its limitations, and acts that go beyond the use of discretion and may be criminal. So after the presentations, there will be a question and answer session, so please feel free to enter your questions in the chat box on the right side of your screen. So now please join me in welcoming our speakers. Lance Gable is an internationally known expert on public health law and bioethics and an associate professor of law at Wayne State University Law School. He served as interim dean of Wayne Law from September 2016 to August 2017. So his research addresses the overlap among law, policy, ethics, health, and science. He has published journal articles on a diverse array of topics, including public health law, ethics and policy, international human rights, bioterrorism, and emergency preparedness, mental health, research ethics, and information privacy. So our next speaker will be Denise Chrysler, and she's practiced public health law for over 30 years. Currently, she directs the Network for Public Health Law's Mid-States region, located at the University of Michigan School of Public Health. She also serves as member of the Ingham County, Michigan Board of Health. So previously, Denise provided legal services to Michigan State Health Department regarding communicable disease, immunization, environmental public health research, privacy, health information exchange, and emergency legal preparedness and response. She served as the State Health Department's Public Health Legal Director, Privacy Officer, Freedom of Information Coordinator, Regulatory Affairs Officer, and member of the IRB. She also represented the Health Department as an Assistant Attorney General. So our final speaker will be Matthew Penn. So as Director of the Public Health Law Program within the Center for Disease Control and Prevention's Office for State, Tribal, Local, and Territorial Support, he provides critical legal expertise and leadership to advance public health practice through law. So in this role, Penn leads a team of public health advisors and analysts and supporting practitioners and policymakers at the state, tribal, local, and territorial levels through the development of practical, law-centered tools and legal preparedness to address public health priorities. So now let's hear from Lance.
Well, thank you, Jason, and good afternoon, everyone. It's a pleasure to be a part of this webinar today. I am going to be focusing on a couple of issues. I'm going to set the stage a little bit in terms of some of the conversations we're going to have today, looking at public health decision-making and liability. But I wanted to maybe even reframe it a little bit more broadly than liability, because what we're really going to be talking about today is public health decision-making and the various types of accountability that can come from circumstances where public health officials end up either making the wrong call or making a decision that turns out not to turn out the way that we would all hope it would, and with people ending up being harmed. There are many examples of this in day-to-day public health practice where a particular decision, even though based on good evidence and reasonable assumptions, doesn't necessarily turn out the way that one would hope. And one of the things that we're going to be exploring today is looking at circumstances where decision-making didn't necessarily turn out well, and what sort of results come from that type of situation, whether it be potential for civil liability, criminal liability, or other forms of accountability that can end up facing public health officials. Now, obviously, as a public official, you have an important role to serve the public good, to make decisions that are designed to benefit the public and to be reasonable in terms of the evidence that is presented in those situations. And so there are lots of circumstances, though, where those decisions don't necessarily turn out the way that they were intended. And there are also situations, although much more rare, where other considerations clouded the decision-making and led to a circumstance where the public's good maybe wasn't the first consideration of the officials making the decisions. And obviously, that presents a whole different kind of circumstance where the accountability and liability that's at stake might be pursued in a different way with those different circumstances. So with that as a backdrop, I want to start by looking at an example from about 40 years ago, and that's the 1976 swine flu pandemic scare. And I say scare, of course, because there wasn't actually a swine flu pandemic in 1976. Early in that year, there were some signs of a potential flu pandemic that were very worrying. There had been an outbreak at a military base in New Jersey. The flu strain that year seemed to be a dangerous strain. It seemed to be spreading rapidly. It seemed to have a higher mortality rate than normal, and there was a concern that this could end up being a large pandemic that was just beginning. And so David Sencer, who was the director of the CDC at the time, recommended that there be a national flu vaccination program to head off this potential pandemic. The vaccination program was rolled out very quickly with great fanfare. There was a big push to get as many people vaccinated as possible. And then two things happened. The first thing that happened actually was something that didn't happen. The flu pandemic didn't happen. And so within a short amount of time after this vaccination program had begun, the actual outbreak wasn't occurring. This could have been because we were just lucky and the strain wasn't necessarily as bad as people had expected, as the experts had expected. It could have been because the vaccine actually helped and people were less susceptible to becoming infected. But regardless, the pandemic never materialized. And of course, when you're working in public health, you all know that it's always hard to prove a negative. And when public health interventions succeed, sometimes it's hard to take credit for preventing something that didn't happen. The second thing that happened was that there were some adverse reactions that were reported widely in the media A number of people developed Guillain-Barré syndrome, which is a neurological condition. Several people died of the symptoms of that condition. And while it was never definitively proven that this was caused by the vaccination that year, those two things were linked very closely in a lot of the media reports, and there were huge movements to resist getting the flu vaccination that year because of the fear that it was actually dangerous. And here you see on the slide a picture of Gerald Ford, who was president at the time, getting his swine flu vaccination in front of the media to prove that it's safe. And so the result of all of this, the fallout from this situation was fairly swift. In early 1977, Joseph Califano, who was the director of the Department of Health, Education, and Welfare, the predecessor to HHS, removed Dr. Sensor as director of the CDC. The national vaccination program was ended, and the reason I mention this example is because it's actually, even though it's an unusual situation, it's actually a fairly typical way that public officials are held accountable for things that don't turn out the way that they had intended. And regardless of whether Dr. Sensor's decision was the correct one or not, the public perception was that it was a bad decision. As a public official who was responsible to other higher up political officials, he was held responsible and accountable for that mistake, even if his decision-making process was not mistaken in the first place. And so this is typically how accountability is achieved with public officials. They're held accountable by, if they serve at the pleasure of a higher level executive official, they can be fired, they can be reprimanded, they can have other kinds of consequences, or if they're an elected official, they can be removed by members of the public at the next election cycle. Another important thing that happened in 1976 that's relevant to our conversation today it happened at the American Legion conference that they were having in Philadelphia, meant to coincide with the bicentennial, and there were about 2,000 members of the American Legion staying at the Bellevue Stratford Hotel, this beautiful building here in the slide. Unfortunately, there was an outbreak of a new virus that had not been previously identified. It turned out it was Legionnaires Disease, and so named after the American Legion members who contracted it at this particular event. Over 200 people, which is about 10%, it was about 10% of the attendees, actually became ill, and about 29 ended up dying from the infection. Obviously, this was a scary situation to have a new disease that had previously not been identified. But Legionnaires' disease is actually something that's very common in the environment, and it's relevant to the next example I want to talk about, which is the Flint water crisis. Now, many of you are probably familiar with some of the basic background on the Flint water crisis, but it is without a doubt the most significant catastrophic failures of public health in recent U.S. history. Here you have a major city in the United States that, due to some decisions made by government officials, ended up contaminating its water supply and causing a great deal of public health harm. Most of the analysis of the Flint crisis correctly, I think, focuses on the lead contamination. And I'm going to talk a little bit more about that in a minute. But what we're going to focus most on is another effect of the change in water supply that caused the pipes to corrode, and that was that there was a higher presence of Legionnaires bacteria in the Flint community during the time that they were using water from the Flint River during 2014 and 2015. And that resulted in some spikes in Legionnaires' disease in the population. And the result of that outbreak and the fact that state public health officials were aware of the outbreak for an extended period of time before the public at large knew about it is that several state public health officials are now in the process of being criminally prosecuted for on several charges, including involuntary manslaughter, for causing the deaths of some of the people who contracted the disease. Now, this is certainly a very unusual set of circumstances because it's extremely rare for public officials to be held accountable through criminal law for decisions that they made that were part of their public duties. And so what the Flint cases present in terms of what they mean for public health accountability is sort of a novel approach to trying to hold officials accountable for circumstances that occurred due to their decisions. And I wanted to take a step back for just a moment and try to give a little bit more background and context to the Flint situation. One of the big factors in the decision-making process here was the fact that Michigan has a state law that allows for the governor to appoint an emergency manager anytime a local jurisdiction or school district has a financial exigency. And so the governor appointed an emergency manager for the city of Flint in 2011. There was a series of emergency managers in the city, and those emergency managers were charged with trying to bring the city's budget under financial control. The emergency managers, it's important to note, are not democratically accountable in any way. They're appointed by the governor. The voters of the city of Flint had no say in who that emergency manager was. There was no way for the people in the city to remove that emergency manager through democratic processes. And effectively, the emergency manager had control over all of the city expenditures and budgets so that any kind of decision made in the city government had to be approved by that emergency manager. One of the decisions that was made early on in 2014 was to move the city from the Detroit water system, which it had been using since 1967, to the Flint River as a money-saving measure. The city was eventually going to, had planned to hook up to a new pipeline that was going to be built coming directly from Lake Huron, but that pipeline was not ready. And so in the interim time, the emergency manager decided to switch the water source to the Flint River. Now, the city had a water treatment plant that it had used prior to 1967, but what ended up happening was the water coming from the Flint River was very polluted. It was caustic. It had a chemical interaction with the old pipes in the city of Flint that were mostly lead-based pipes, and led to lead leaching into the water supply. And the treatment that would have been required to prevent some of this leaching was very inexpensive. It would have only costed something like $200 a day, according to some of the reports related to this incident. But yet the city didn't take those precautions, and the water supply ends up getting very contaminated. So after the switch to the Flint River, a few months later, there's the first Legionnaires outbreak. There were 30 cases in Genesee County, which is where Flint is located. By January 2015, the head of the state health department is notified of the Legionnaires outbreak. The state health department at that time conducts some additional investigations, but doesn't inform the public or do much more immediately. In September, the health department again gets updates on a second Legionnaires outbreak. And then moving forward, in September of 2015, Dr. Mona Hanna-Attisha publishes her findings of elevated blood lead levels in Flint children. And this was the time, there had been immediately after the switch to the new water source, there had been multiple reports in the media and complaints from people living in Flint that the smell, the taste, the appearance of the water had changed drastically, and people were having negative health side effects, including rashes and other kinds of symptoms. Dr. Hanna-Attisha's study was the first to show definitively that the lead levels had been elevated in children who had been exposed to the water supply. And the next month, in October 2015, the Genesee County Health Department declares an emergency. Also in October 2015, the city reconnects to the Detroit River again and stops using the Flint River as its water supply. In December 2015, Robert Skidmore, who's an 85-year-old man, resident of Flint, who was being treated in a local hospital, dies from Legionnaires disease. And in January 2016, finally, the governor of Michigan declares a state of emergency and notifies the public of the Legionnaires disease outbreak. So the health consequences are vast, and they're going to be unfolding for many years. Obviously, with something like lead contamination and lead exposure, the long-term effects are not immediately known, and lead can have neurotoxic effects, developmentally damaging effects on children and on adults as well, but particularly on children. And so the evidence is just starting to come in, but a recent study that was released a few months ago showed that during the time period of exposure to the Flint River, to that lead-contaminated water, fertility rates in Flint fell by 12%. And fetal deaths increased as well. And in addition to all of this, there are at least 12 deaths that are attributable to the Legionnaires disease outbreak. Now, when we're thinking about this kind of situation, the big question that's asked related to Flint and is being asked right now in the courts is, did the public health officials, in their decision to not immediately notify the public of the Legionnaires outbreak, was that a reasonable decision? Was that a decision that made sense under the facts of the circumstances at hand? Is that the kind of decision that could possibly lead to liability for those officials if it's determined by a court that they didn't use appropriate care or that they had other motivations behind making the decisions? And so when you're thinking about methods of public health accountability, methods of accountability for any public official, but including public health officials, one method is fairly mild, or you can perceive this as the most mild of the list here, criticism and feedback. Obviously, there are multiple ways to achieve some level of accountability through external criticism, either through public advocacy or media scrutiny of actions of public officials. And this was certainly true in Flint. There were many organizations, and both media organizations and community-based organizations that called attention to the impact of the effects of the Flint water, and those organizations were really instrumental in getting the water supply change back to Detroit and some of the other consequences that have come from the situation. The criticism and feedback can also come internally to the government. There are many mechanisms within the government to try to hold officials accountable. They can be reviewed internally through oversight processes, and this can either be within their own agency or it can be across the government. So the legislature can perform oversight, and there can be external special committees, which there actually were related to the Flint water crisis as well. And so another set of accountability methods are, of course, sanctions, firing, and democratic accountability, voting officials out in the next election if they're subject to election. And the last two here, which we're going to focus on for the rest of my time period, civil lawsuits and criminal prosecution. I'm not going to say much about civil lawsuits because Matthew's going to cover that in his presentation. And so I'm going to focus primarily on criminal prosecution. Now, as I said a few minutes ago, criminal prosecution is very rare. It's not something that happens very often against public officials. And when it does happen against public officials, it's usually a very specific kind of case. It's usually the kind of case that doesn't involve the kinds of circumstances that happened in Flint. It usually involves more direct corruption. It involves either taking bribes or getting kickbacks for trying to enrich the person themselves or their family or other favored people that they choose to try to help outside of the scope of the normal appropriate behavior within that public office. And a good example of this is there was a case from 2011 in Detroit where there was a city official who worked for the city health department who was a lead inspector who had been taking kickbacks from people, essentially soliciting bribes from homeowners and business owners and landlords who had lead abatement problems. They needed to remove lead paint. They didn't want to do it, so they paid off this inspector to write them a a clean certificate of health saying that they were in compliance with the lead rules. And when this was discovered, this particular inspector was prosecuted by federal prosecutors and convicted and sent to prison for 46 months. So that's a more typical kind of criminal accountability for a public official, where you're kind of on the take for your behavior. Now, what happened in the Flint situation, though, is very different. And so that's why I believe it's a real outlier, and I don't think it opens the door to the widespread use of prosecution for purposes of public health behavior. So I'm going to kind of slide past this slide and not stay on it for very long, except to make two really quick points. One is that the criminal and civil accountability systems are very different. Importantly, the criminal system has to be initiated by state officials. It has to be initiated by prosecutors. And the point at the bottom is particularly important, that the types of immunity defenses that Matthew's going to talk about in a few minutes are not as applicable to criminal allegations, because criminal allegations, almost by definition, are behaviors that are outside the normal scope of practice of that person's public responsibility. The other important point is that when there's a criminal case against public officials, the government is representing both sides in the case. There's the prosecutor who works for the government and the defendant who is also a government official. And so the other result of that is that the government ends up paying for the legal fees for both sides of the case, instead of spending that money on other things like, say, improving public health. So just to wrap things up, because I know my time is just about out, I wanted to make a few final comments. These pending criminal charges have been filed against several of the public health officials, including the director of the state health department and including the medical director, charges of involuntary manslaughter, and also misconduct in office, conspiracy, lying to a peace officer. And these are fairly serious charges. The reason that I think these charges are moving forward right now is because there really was an accountability vacuum. There weren't a lot of other successful attempts to hold anyone accountable for the decisions that led to the harms caused by the Flint water crisis. And therefore, using criminal law was one of the options that was still open, and I believe that's one of the reasons why it's being pursued so vigorously. There's also political considerations within state politics that make it a ripe target for prosecution. I do think there are some challenges to trying to use criminal law in this way, and I think ultimately it's not a very good method of accountability for the kinds of decision making that public health officials make every day. And I believe the Flint case in that respect is quite an outlier. I'm going to wrap up right now, but I look forward in the question and answer session to talking more about some of the aspects of this case and what it might mean for public health practice. So thank you very much, and I'm going to pass things over to Denise, who's going to take it up with the next presentation.
Great. Thanks a lot, Lance, and thank you, everybody, for attending today. As Lance noted, health officials make difficult decisions every day, and a hallmark of the decisions they make is they're based on limited information. So they're always weighing, do I act now? Do I implement measures? What's the risk of acting prematurely? Or what's the risk of waiting until I have more information so that I can have improved decision making? And while the Flint situation is the one that's received so much attention, when I think about the issues in decision making, I always think about the difficulties of when you warn and what you warn with regard to foodborne illness. What if it ends up not being the strawberries and you've destroyed an entire industry? So I'm going to be putting routine decision making, and to some extent this would be applicable to the Flint situation, into a legal parameter, and I call it the can I, must I, should I. Can I take action if I'm a health official? Must I take action? Do I have a duty? Or should I exercise my discretion and act in a particular fashion? So here's the 3 questions. The first one, can I, is a legal question about do I have the authority. The second one, must I, is also a legal question. Does law leave me no choice? And the third one is a policy question. How should I exercise my discretion? And another way to think of these 3 questions, can I is my power, must I is my duty, and should I, again, is my discretion. So a lot of the can I, the do I have the power for public health officials is in the broad and flexible police powers, the power of the government to protect this, to act to protect the health, safety, and welfare of the people in our country. And often these powers are exercised under general powers. Not everything is set out specifically in a statute that a health officer does. And this language is typical of language that's in every state's law, or yeah, I think I'm safe to say every state's law, which are powers necessary and appropriate to perform the health officer's duties, the powers necessary to promote and safeguard the public health, to prolong life, to prevent and control health hazards, to prevent and control the spread of disease, and to provide expertise and education regarding health. We also have very specific powers concerning very specific threats, many laws that set out licensing schemes, that set out standards that those who are regulated must meet, set out the different kinds of inspection requirements, the options for enforcement. But even within these specific powers regarding specific threats, there's often a lot of room for discretion in how those powers are exercised. So broad and flexible powers. Police powers does not mean a police state. So what are the limitations? There's jurisdictional limitations. We have, powers that belong to certain branches of government, powers that belong to certain levels of government, be it federal, state, or local government, or powers that belong to or assigned to particular agency. In my state, pesticide regulation, even though it involves the public health, that's exercised by our agricultural department, not our health department. Then territorial limits, if I'm a health officer in a particular county, then I can't take action in another county. Statutory limits, and then preemption, where a higher level of government limits what a lower level of government can do. There's also limitations based on our Constitution and all of the individual rights of liberty, due process, protection against search and seizure, equal protection, right to privacy, freedom of association, freedom of religion, and just compensation. Then there's limits on the limits. Individual rights don't always supersede the public good, and probably everybody on this call is familiar with the case of Jacobsen versus Massachusetts and mandatory immunization, that there are many restraints that every person is subject to for the common good. Jacobsen versus Massachusetts also has a caution, though, on the exercise of police power. And if it is exerted in an arbitrary or an oppressive form in a particular case, that would justify the interference of the courts to prevent wrong and oppression. So after the can I, do I have the authority to act? Is the must I? Am I mandated to take action? And am I mandated to take a particular action? This is the key part of the charges against the Flint, the health officer, the state of Michigan health officer in the Flint case. And that is a question about the duty to take action to protect the public's health and whether the health officer acted in accordance with that duty. So mandatory may be mandated by law. It may be mandated by funding sources. Money with strings. If you receive federal money for your WIC program, there's a whole set of federal regulations that you must implement as a condition for taking that money. Even when there are mandatory functions, it often includes discretionary functions involving the exercise of judgment and discretion. So law may mandate something, but often an agency has a great deal of discretion in determining how to fulfill its obligation. So again, Flint, what is a duty? It's a legal duty, an obligation created by law, and that's in comparison to a moral duty. If you have a legal duty, then there's a right. To have a duty means somebody has a right. To whom is the duty owed? How is the right enforced? There's a doctrine of public duty, also known as no public duty. This applies in some states and not other states. Often it's thought of in terms of the police and law enforcement. They owe a duty to everybody, but may not owe a duty to a particular individual to intervene in a particular situation. And when you look at duty, should there be? Is there a difference between action of the government versus the government failure to act or failure to warn, as in the Flint case? And then, as Lance was pointing out, Flint had certain special relationships, did have what might be argued as a state-created danger because it was the state that imposed an emergency manager that had expansive powers. And so the people of Flint, being subject to the powers of the emergency manager, did that create a special relationship and create certain duties that the government had. So mandatory plus discretion. So the must-I is usually a mandatory, I'm obligated to act, like the Department of Public Health. This is Michigan's, a paraphrase of Michigan's law. The Department of Public Health shall promote and safeguard the public health and prolong life, et cetera, but often that involves discretion. This is the way that the U.S. Supreme Court has described the must-I, that the government may have a duty to provide certain services or to act in a particular manner, but that doesn't mean they're obligated to act in a certain way. They have considerable discretion in determining the nature and scope of their responsibilities. And the state also, as the Supreme Court goes on to say, does not always have to choose between acting to attack every aspect of a problem or not attacking the problem at all. And that's called selective enforcement. Generally, government officials, police officers, health officers, et cetera, have the power to choose whether or how to punish a person who's violated the law, or how to whether or how to take regulatory action. But they can't do that in a biased use of their enforcement discretion, such as enforcing building codes against one ethnicity and not another ethnicity. So most of public health decision-making comes in the realm of should I, based on discretionary power. Should I act in a particular way? Should I take action at all? Actions must be used reasonably and partially, and there's so many policy considerations, everything from do I have the resources, what's the feasibility of being effective, what would be the impact, what are my priorities, is this a population health issue, or is it a private dispute, for example, between neighbors that should be resolved among the neighbors? Am I acting uniformly, uniformity being sameness, treating everybody the same, versus am I acting consistently, where there may, uniformity would be like 3 strikes and you're out type of laws, where consistency is, am I adhering to a particular set of standards, but taking into account individual situations. And what is the strength of my evidence to act in a particular fashion or to take action? What's the strength of my legal authority? Public opinion, will the public be behind me? Am I too far out ahead of the public? And then politics, how relevant, where is it relevant? Politics seems to impact everything, but at the same time, the worst thing you can, the most negative thing you can say about somebody is they acted because of politics. Then finally, just the notion that doing nothing is doing something. And so if you do nothing, doing a risk assessment of what that means. So the should I, making choices versus abusing one's discretion. And making choices, you would consider the facts, the principles, and the law, be able to articulate the basis for a decision, show that you considered and weighed alternatives. The bottom line, does this decision make sense? Is it reasonable versus decisions that are arbitrary and capricious? The arbitrary and capricious are usually the terms used for an abuse of discretion. To repeat, doing nothing is doing something, so make certain it's a conscious choice. Arbitrary, meaning not considered, ignores the facts, whimsical. Capricious, meaning impulsive and unpredictable. These terms come up all the time in law. They may be defined by statute, as in this Florida statute concerning rulemaking and whether the definition of whether a rule would be arbitrary or capricious, and often comes up in judicial opinions, and the judiciary is always defining these two terms and assessing compliance with these, whether a particular decision is arbitrary or capricious. So building support and reducing exposure, even exposure to criticism, and then exposure to liability. Engagement, and in the Flint case, it wasn't just engaging the community, which is essential, but in Flint, it was also engaging other governmental entities and working together and coordinating actions. Transparency, risk communication, and then documentation. What are the facts known at the time of decision, the basis for decision? Because if things go south, there will be second guessing based on hindsight. Health officials have pointed out to me the practical challenges in documenting decisions and how decisions are made in public health, how and where to document decisions. They're group decisions, they're evolving, they're iterative. It's not like a doctor makes, has the patient record, makes notes, lists the options that were considered and the basis for a choice. The Network for Public Health Law does have a public health decision-making tool. The link to the tool is here, and it asks several questions to help you make decisions, and the answers to these decisions change by the moment depending on what information you have. You know, what are the facts at the time? What is the threat? What are the consequences? And what's the likelihood of harm occurring because of this threat? But the biggest thing is the certainty again. Should you take action now? Should you wait until you have more information? And what are the risks in doing either? And then the communication. What do you communicate to the public, and when do you communicate it? So, of course, we all know hindsight is 20/20. If only we had a crystal ball and we could see the future, it would certainly, I'm sure, in many, many situations in making, looking back, it's only if I had known then what I know now, I would have acted very differently. And then when things go south, Lance just talked about the differences between the criminal justice system and the civil justice system. Matthew Penn, who will be following me, will talk more about the civil justice system and when do we hold the government responsible, when do we hold governmental employees responsible, or when, because of the unique nature of government and the role of governmental employees, are they protected from liability? And with this, I will turn it over to Matthew Penn.
Great. Thanks so much, Denise. Hello, everyone, and good afternoon. And thanks for tuning in to our webinar here on executive decision-making and liability. And I'm going to be talking about mostly about liability and immunity. So we've heard from Lance about some specific decisions and circumstances that have happened in the past where folks in public health have been held accountable for those decisions, and a little bit from Denise on how leadership in health departments kind of think about decision making and some of the factors that play into that. So my presentation here, we're really picking up where those leave off and talking about, well, let's talk a little bit about liability and what that is and what that looks like, and talk about some of the immunities that may be available to folks in public health. Of course, attorneys, we have our disclaimers. I am an attorney. I'm a licensed attorney in the state of South Carolina, but I am not your attorney. These situations are complex, and certainly the applicable laws vary by jurisdiction. So if you're curious about how your jurisdiction laws affect your particular situation, I encourage you to contact your advising attorney and have that conversation. And I represent the Public Health Law Program here. We work in legal epidemiology, workforce development, partnerships, and communications. We work with CDC programs, state, tribal, local, territorial communities, and folks like yourselves. And if you ever have any questions about public health law, I have a great staff, and we have a lot of folks here with expertise in answering your questions. And if it's something that we don't know about, we have friends like Denise and Lance and folks that we can call to get you the kind of information that you need to understand better where law fits into your world. So let's talk a little bit about what I'm going to talk about, what we have on tap today. We're going to really talk about some basic nuts and bolts of liability and immunity, and try to take apart those puzzles a little bit and figure out what exactly they mean. We're going to talk about what a claim is, what is it that we're talking about when we talk about liability, what is a tort. That word gets thrown around a lot, so we'll try to take that apart and see what it says. Talk about constitutional claims. Denise talked about some of the individual liberties that are caught up in our constitutional rights, and what does it mean when we say somebody brings a constitutional claim and says that their rights have been violated. And finally, if these claims are brought, we'll talk a little bit about lawsuits. If you're subject to a lawsuit, what are at least some of the defenses that are available to us in governmental public health. So I kind of thought the first good place to start really is with the idea of a claim. A claim, when we think about it from the lawyer's perspective, a claim really is a legal statement that someone brings and articulates that somebody else has injured them, and that the person who's been injured is is asking for some sort of compensation or some sort of action from the person who did the injury. So classic example is I'm driving my car, I wreck my car into someone else's car. That other person could bring a claim against me and saying, hey, the guy hurt my car, hurt me, and I want that person to pay me some money, and I want that person to get my car fixed. And they bring that claim against me. I mean, a claim is a very important part that you sort of see through this idea of liability and also immunities. So it really kind of brings up this next question, which is, well, what exactly is liability? The word gets thrown around a lot, and I think it can be helpful to bring us back to exactly what that means. And in one sense, it's really pretty simple, is that liability is a legal responsibility. And what we mean when we say that someone is being held liable, or someone may be held liable, or someone has been found liable to someone else, is that they are found after a legal process, after some sort of legal proceeding, they are then, as a result of that legal process and whatever they did in the past, they're then obligated to perform some sort of act. They're obligated to stop some sort of behavior or activity, or is often the case to pay some sort of money damages to the party or parties that have been injured. It's about legal claims being brought, there being some sort of process, and then what we typically think of as the defendant, the person who's been sued, is then under obligation to then do something. And if you don't, you can get in big trouble with the judges that presided over the legal process. You got to do something, you got to stop doing something, you got to pay somebody money. That is the essence of what liability is in the legal sense. So let's talk a little bit about what a tort is. And a tort fits into this puzzle in that a tort is a type of claim that you can bring against somebody else. So that car wreck, I could be guilty of a tort, and the person brings that claim against me. So what exactly is that when we talk about that? Well, it's a violation of a duty imposed by law for which some court, some sort of legal tribunal is going to provide a remedy or some sort of compensation. This idea that you're found liable and you're going to have to pay some sort of compensation or do something for somebody else. And tort is kind of broken up into different elements. And these elements are necessary. You got to show all these things. There's got to be a duty, there's got to be a breach, causation, and damages. And you've probably heard these terms thrown around a good bit if you're not a lawyer. If you are a lawyer, you heard them in law school ad nauseum. If you haven't been, you probably heard these terms, but they all kind of fit together to form this thing called a tort. So what do they mean? Well, a duty, it's a bit commonsensical. It's really an obligation to exercise reasonable care. So as we move through our daily lives, because we live in a society and we live within a closely knit population, we really have an obligation to other people to exercise reasonable care in the things that we do, how we handle ourselves in the world, and how we handle ourselves with our activities. And so when you're driving a car, again, in that scenario, in that hypothetical, you have a duty, you have an obligation to operate your motor vehicle and your car with some level of reasonable care so that you don't hurt other people, right? You go all just crazy in your car, there's a good chance you're going to hurt somebody, and we don't want that. And so we roll that idea of a duty into this legal thing called a tort. So what happens is, though, sometimes we don't exercise reasonable care and we breach that duty. We breach the duty to exercise reasonable care. And very often you hear people talk about that breach as negligence. That is where that word comes in. So if you say, wow, that guy was so negligent, I couldn't believe it. What you're saying is, whether you knew it or not, you're saying that person had a duty to do something and that they failed to do that something with reasonable care. And that breach is then starts to get you closer and closer to having and proving some sort of tort. So then we get to causation, and what you show there is just causation. That breach, the failure to exercise reasonable care, then resulted in some sort of injury or damages to somebody else or a group of people potentially. So you got a duty to exercise reasonable care, you don't because you're going all crazy, and then you injure somebody and they can say, wow, that going crazy caused my damages. You've got now duty, you got breach, and you got causation. And then finally the thing that you have to prove, and as part of a tort, is the damages. So the injured person has to come in and say, the guy ran into my car, and you know what, it cost me $10 to fix that car, and those are my damages, the $10 to fix my car. Or that person broke my leg, and I had to go to the hospital, and I had all these medical bills. Well, those medical bills are my damages, and I had some pain and suffering, and those are my damages as well. So if somebody who's been injured can roll all four of those things together and approve those through all of the legal mechanisms we have, then you've got a tort, and somebody may have to pay money or take some other sort of action, maybe obligated to do that. So a tort is a type of claim, and we also have constitutional claims. You can be injured in a way that your constitutional rights have been violated. You might not suffer any sort of physical injury from having your constitutional rights violated, but they may be violated nonetheless. And you can bring a claim saying that a governmental official or somebody acting under the color of law has violated or impinged upon the exercise of your constitutional rights. And of course we're talking about, and Denise had some of these in her presentation, we have freedom of speech, freedom to exercise a religion, we have certain due process rights, procedural and substantive rights to life, liberty, and property. And you can bring a claim against governmental entities that they have violated those. But it's different than a tort. But it is still a claim, a statement, a legal statement that someone has injured you. We even have statutes that allow us to do this. This 42 U.S.C. Section 1983 is a federal law that opens the door to individuals to bring constitutional claims against governmental entities or folks acting under the color of law. So how do these things relate to lawsuits? Lawsuits are, they're interrelated, claims and lawsuits, but they're a little bit different. A lawsuit really is the way that it's a system we've designed that allows people to kind of package up those claims and then bring them into a tribunal. We usually call them courts. But it's a way that you can roll up those claims together, and then you can present them formally to some sort of arbiter, some sort of judge, a court, so that they can be heard in a relatively civilized manner under the rules of law. Lawsuits can certainly be grounded, can find their source in torts, they can find their source in constitutional claims, and oftentimes, if you're going against governmental actors, you might find them combined in two. You could bring up a tort claim, and you could bring a constitutional claim in the same lawsuit, and then have those adjudicated in the court system. So lawsuits are a way to package up claims in formal statements and get them into some sort of tribunal system. So let's say that happens, right? Let's say, and of course, we know, I'm sure there's a lot of folks on the line, the folks that work in health departments. Health departments get sued. Health departments get sued for a lot of things. I litigated cases for my health department when I was an advising attorney, and lawsuits are brought against health departments. So let's say that happens. Let's say somebody files a lawsuit against your health department. The first question, and believe me, often the very first question when the person who gets the lawsuit walks through the door is, what am I supposed to do about this? How do I answer? what are my defenses? And then they lay into some diatribe against the factual scenario, trying to demonstrate to me that they are innocent or not liable. So we're today going to talk about a few defenses that are available. Of course, one defense is you can just say factually the presentation of the case is not accurate. We're not going to talk about that too much because it's always case specific, all the facts change. But we do have a few defenses that seem to be pretty consistent across the 50 states and available in local jurisdictions and tribal jurisdictions and territorial jurisdictions. And they fall into really some categories here. We're going to talk a little bit about sovereign immunity, a little bit about tort claims acts that exist in our jurisdictions. We'll talk a little bit about qualified immunity and some about absolute immunity. And again, the context here is there's a lawsuit that's been filed, and you're trying to figure out how do I defend against these claims that are contained within this lawsuit that has my name on it and my health department's name on it, and goodness gracious, what do I do? So the first one, and this is really for governmental entities, governmental health departments, we have this idea of sovereign immunity. And sovereign immunity is a doctrine, it's a legal doctrine, and it really is the idea that people are precluded from asserting what may otherwise be a perfectly valid claim, maybe a fabulous claim. But sovereign immunity says you're not allowed to bring it against the government unless the government consents to that claim being brought against it. Sovereign immunity dates back to before we were a country that we recognize today, back from the English crown, and basically the kings and queens said, I am the sovereign and you can't sue me. You can't sue the king because we're the king. Can't sue the queen because I'm the queen, and you just can't do that. This was rolled into the colonies, and we received it from, that issue of colony law when we became states under the Articles of Confederation, and it's continued on since then. And part of the idea as we transitioned from a monarchy system to a democratic system, part of the public policy of this idea is that by suing the government, you're really suing yourself, because who's going to pay? Well, you're going to pay. We all contribute tax monies to the coffers, and damages are going to be paid out of those coffers. And so we need to be careful how we allow citizens to sue the government, because the government is supported by the people. So we're going to have some parameters around this. But the important thing is that you can waive sovereign immunity. And in fact, many states have waived sovereign immunities, which means that then you can sue the government. So the default starting position is governments have sovereign immunity, you can't sue them. But many states have said, well, but we kind of think there's probably some circumstances in which it's okay to sue the government, so we're going to waive sovereign immunity. But then on top of that, then they make exceptions to the waiver. So again, that whole thing about getting legal advice is a good idea, because it gets complicated really fast, and even for us folks that are familiar with it, it can get complicated really fast. As I said earlier, results vary by state, and there's a tremendous amount of variation in the way that states handle sovereign immunity. This is an example here is that some states have waived sovereign immunity and said that, yes, you can sue the state. But in the public health world, some states have said, but you know what? If the state imposes a quarantine, you can't sue the state. That's an exception. So again, results, as with many things in our laws across the 50 states, results can vary dramatically. So where do state tort claims acts sit in all of this big puzzle? This is a place where states talk about this idea of sovereign immunity, and states have generally have statutory waivers of sovereign immunity that allow folks to bring tort claims against the state with the exceptions as I talked about, or they may put in place some specific immunities with limited waivers on certain types of claims. State tort claims acts are statutes. Many states, more than 30 states, have caps on how much an individual can receive in a claim. So they've waived sovereign immunity, which means you can sue them for a tort, but they're going to put a cap on how much money you can get from them. Again, because we all contribute to that pot of money. And so we don't want any one particular individual to get too much out of it because we all contribute to it, including the person that's doing the suing, right? And importantly for our conversation today in decision making and being held accountable and getting a claim brought against you and being sued through a lawsuit is Tort Claims Act. Many Tort Claims Acts have provisions that require the removal of official and employee names from the lawsuits. So in your state, it may be that your state Tort Claims Act or whatever mechanism that you have in your state for sovereign immunity and bringing claims against the state may have a provision that says if you are sued in your individual name, it's required by law that your name is removed from that lawsuit and your governmental entity put in there in replace, or that the name of the health department, say, stays in the lawsuit, but your name is removed. Now, something important to remember is that many of these ways to get individuals out of these lawsuits are not going to work if you are reckless or grossly negligent. So if you're really negligent, then some of these defenses may not be at your disposal. And just to show you some of the variation here, South Carolina Tort Claims Act that I'm somewhat familiar with, you know, it says here, the state and agency, political subdivisions, and the governmental entity are liable for their torts. But they're subject to limitations and liability and damages, as we're going to talk about in the rest of the code. And there may be exceptions to some of those waivers. South Carolina has a lot of exceptions to the waiver. So those exceptions, you can't sue under those things. And some of them are super broad, you know, exceptions to the waiver of immunity, adoption, enforcement, or compliance with any law, or failure to adopt or enforce any law, whether valid or invalid, including but not limited to any charter, provision, ordinance, resolution, rule, regulation, or written policies. That's super broad. So again, it behooves you, if you're ever subject to a lawsuit, to get with a local attorney and figure out how this works in your jurisdiction. And of course, we have a way, there is a way in South Carolina that you got to be acting within the scope of your duties. You can't be grossly negligent or wanton and willful conduct is the way sometimes that it's talked about, and that the agency or the political subdivision for which the employee was acting must be substituted as the party defendant. This is how the individual gets removed from the lawsuit. Washington is totally different. Washington just has waived sovereign immunity, no limit, no cap on the claims against the state. So again, there's many variations here on how state claims acts, tort claims acts are written and expressed. So let's talk a little bit about immunity. Again, we have sovereign immunity. We have a couple others that I'll cover just quickly. My time is running out here. Talk about absolute immunity and qualified immunity. Absolute immunity is a doctrine that really just precludes claims. So it just blocks the claim itself. And for absolute immunity, it is exceedingly rare. And how do we know if it applies? There are things to run through. It might be something like the decision of a prosecutor to bring a case or not. Judges have certain types of absolute immunities in the decisions that they reach. So it's pretty rare, and the Supreme Court of the U.S. has put down some pretty strict elements on who can get absolute immunity and under what circumstances. Qualified immunity is a little bit different. This protects government officials from lawsuits alleging that they violated plaintiffs' rights, and allows suits only when officials have violated a clearly established statutory or constitutional right. We just want to make sure that the claims are based on recognized and true rights. We only want those to go forward instead of maybe some squishy rights somebody's trying to make up. But it's really these clearly established statutory and constitutional rights that we're going to allow these lawsuits to come forward on. And really, the question to ask is whether or not courts, they really look at whether a hypothetical or reasonable official would have known that the conduct was violating somebody's rights. So it needs to be a clearly established right, and then there has to be some awareness on the part of the government official that the activity or the behavior or the decision was going to violate a right. We're really trying to balance these things, and Lance and Denise both touched on this. It's really a balance between holding public officials accountable, in this case accountable under the law, but also the need to shield public officials from frivolous lawsuits, harassment, distraction, and liability so that they can focus on doing what we need them to do, which in our case is to protect the public's health. So with that, I'll wrap up and thank you for your time and attention.
Thank you, Matthew, and thank you, Denise and Lance, and thank you to everyone in the audience for joining today's webinar. So we're now in the Q&A portion of the event. So please use the chat function to send us your questions. So to get started, I'll ask a question that we've already received. And this is for all the panelists. So decision-making is a fluid action and very much based on what information is available at a particular time. So how do you educate decision makers on the reality that it's okay to make a decision and change your mind? And how can this be communicated to the public effectively?
This is Matthew. I could take a stab at that one. I think, I mean, for me, when I would think about it, I would think, well, obviously you can only make a decision based on the information you have at hand. As you know, Denise said, we wish we had crystal balls, but we don't. And I would always emphasize the importance of just making sure that the information that you have at hand is accessible in a week or a month or 6 months or a year. Documentation sounds so formal in the sort of in the midst of decision making or in the midst of a crisis can sound a bit daunting, but it's the idea that, you know, we need to be able to look back at what you're looking at now, because that's what's going to be evaluated. That's what people are going to ask for when they bring a claim or they bring a lawsuit. They're going to say, well, what did you know? What were you looking at? That's the first step. And then the other part of it is, you know, obviously things can change, and if you've gone about it the right way in the first time, so if you're making a decision based on the information you have at the time, and you have to make a decision, but then you receive new information causing you to change, again, you want to make sure that that information that you're using, the new information, is available in a week or a month or a year. But then making sure that there is a connection between the new information you have and the way that you're changing your decision. There's got to be a nexus there. There's got to be some sort of causality between what you're looking at now and maybe you have more cases, something is spreading, you've learned something is more severe than you thought, and it causes you to reevaluate a decision you made previously. But the way that you change the decision needs to be connected with that new information. And again, it's just got to be done in a way that people can look back at it, because people are going to ask. You got to be able to look back at that new information in the same way that you looked at the first batch of information.
Yeah, this is Lance. Let me just chime in here as well. I think the other way to help kind of document what the process was for decision making, especially when you're changing your mind and moving to a new position after additional information comes in, is to actually try to have some kind of written documentation of that change and the reasons for that change. I'll add the caveat that Matthew added at the beginning of his talk, which is that this is not me giving anyone specific legal advice, but you should consult with your attorneys and talk about ways that you can create the kind of record to justify decision making that if it's ever questioned later on, you can point back to that information and what you were thinking at the time and why you made the decision that you did, which I think would help in many cases to justify that decision and the information on which it's based. The other thing I wanted to just say really quickly, just a correction from earlier. Someone pointed out in the Q&A thread that I referred to Legionella as a virus, which it is not. Legionella is a bacteria, and so I just wanted to make sure that was clear to everyone that might have been misled by what I misspoke earlier on.
This is Denise. I'll just add to Lance and Matthew, who've covered the question well, is there are experts who specialize in risk communication and assisting with knowing what to communicate to the public and when to communicate it, and probably the worst thing is not to communicate at all and to have silence in the face of some sort of threat.
Yeah, thanks for your responses to that question. So for this next question from two attendees, and there are two questions sort of related. So one person asks, how much of the Flint decision-making flaws might have been due to lack of clarity or accountability of the county health department versus the state health department? And then another person asks, in Michigan, both state and local public health departments seem to have responsibility to act and protect health. Was that a typical situation where more than one level of government should respond to a threat? And how does this impact liability? And I'll go a step further. How does this affect the duty of the state health departments and the local health departments?
This is Denise. I think this question, this area of inquiry just hits the nail on the head. And I'll just mention Peter Jacobsen at the University of Michigan School of Public Health and Colleen Healy-Bofides at the University of Michigan have done extensive studies on who had what authority in the Flint situation to act and all the challenges when the authority is either not clear or there are multiple agencies with authority. And in Michigan, I'm not giving legal advice, but I did practice under Michigan law for many years. In Michigan, we have a state health department and a local health department that have identical powers. And the law does defer to the local health department as the first responders, but at the same time, the state health department has the authority to act in the case of the local health department not sufficiently taking action, or if an emergency impacts more than one jurisdiction, or if the state health department is simply in a better position and has the resources. So having multiple jurisdictions either clearly not having authority or all having authority can also lead to the challenges of inaction as folks sort through who should be acting or deferring to one another.
Yeah, this is Lance. I'll add to that a little bit as well. I think in the Flint situation, the distinction between the duty of the state versus the local health officials is probably something that will come up in the actual criminal hearings as a potential defense that the state officials could raise to say, well, we were acting within our reasonable duty. We were expecting the local officials to take the lead on this, and therefore we didn't immediately respond. Although, as Denise correctly points out, I think that doesn't necessarily that's not an argument that is airtight. And I think because the duty exists at both levels, there is still a case that can be made that they had a level of responsibility. Now, where that responsibility kicks in and where it actually whether it actually would be a sufficient breach of that duty, a sufficient violation of that duty to justify these kinds of criminal charges is a whole other issue. I think in addition to duty, the challenging aspects of the criminal case are going to be issues of causation as well. Did the decision by the state public health officials to not notify the public of the outbreak, did that cause the specific deaths of the people who ended up dying from Legionnaires in this situation? And I think that's another area where the prosecutor will have a challenge to try to prove that to a jury sufficiently and to make that case. And the defense will dispute that there's a close enough connection between those two things.
Yeah, thanks, Denise and Lance. So my next question is, so can you speak about the duty of public health to advise and warn and protect when there's no sort of a triggering event or creating a situation that occurs? So for example, what about the situation of where there's naturally occurring groundwater known to be hard and corrosive and which can leach lead into drinking water and creating a health risk? So what's the duty to warn in that situation when there's no triggering event, but there may be underlying unsafe conditions?
I'm not sure if this is responsive, but I would go back to not only the power but the duty of public health to provide its expertise and education to the public regarding the health, and then of course the discretion of which issues are addressed and to what extent they're addressed. But public health all the time is providing expert opinions and is providing education and outreach to the public with regard to various health problems without a specific triggering event.
Thanks, Denise. So I wanted to ask about this question we received from a mental health professional. She says she's subject to Tarasov Regents law, where the duty to warn supersedes confidentiality, so safety trumps all considerations. So is this law applicable to other healthcare professionals and in other settings?
Denise will jump in again. I use Tarasov all the time when I think about communicable diseases, and I'm thinking about privacy rights and communicating. There's rare and compelling situations where it may be necessary to identify an individual with a extremely serious, highly contagious disease. And I would think there's an analogy in that situation. It's my understanding health officials have situations where an individual may have HIV/AIDS or some other communicable disease that they, for example, do not tell their partner or spouse about, and they're always having, or they're at times having to weigh the issues that come up in Tarasov and in somebody's privacy concerns and protecting a specific individual. The question I would raise is my memory of Tarasov, and I haven't looked at it in a while, is it's talking about strong evidence and a threat against a specific individual rather than, say, the public at large. So that may be a distinguishing factor for a lot of public health situations.
Yeah, and this is Lance. I agree with what Denise said. I think that there are certain kinds of circumstances where a public health official would be justified in revealing information in order to protect someone against identifiable direct threat of infection or some other similar kind of circumstance. Generally speaking, healthcare providers in general don't have the same specific duty to warn that mental health professionals do in the Tarasov type situation, where you have an imminent threat against a specific identifiable individual or maybe identifiable class of individuals. There are some other examples where there is an explicit legal duty, though, to warn or to report people, and so most states have provisions that that require reporting of child abuse and elder abuse by certain types of professionals, and in many cases including healthcare professionals.
This is Matthew. There may be other, and I agree with what Denise and Lance have said, and there can be situations where factual scenarios just really dictate the need to share information to protect individuals who may be at harm. There also may be specific provisions similar to what Lance is talking about, that many states have laws that get to this issue in terms of bloodborne exposures. So it could be accidental needle sticks, and there are procedures and processes that states go through to inform the individual who suffered the stick of the potential exposure, and then potentially testing to be done after that. It's just another situation where what we normally think of as confidential information may be shared to protect the health of another individual.
Thanks for your responses. So have any of you heard from any health department officials on the effect of the Flint cases on their decision-making process?
I have not. This is Lance. I think it's probably too soon, or at least since the cases are still playing out, and we don't really know yet how they will be resolved, whether there will actually be any kind of convictions related to these charges. I mean, it's still very much up in the air whether this approach will actually yield punishment for the officials. But I've heard nothing specific from other departments who are making any changes, although I'm sure everyone's following it very closely.
Thanks.
This is Denise. I do presentations to local public health officials and practitioners in Michigan, and because of Flint and because of the anxiety I've heard expressed about Flint, I added a lot of the slides you saw in my presentation today to really, talk about what are the legal parameters of decision making.
So we have time for one last question. So I wanted to ask, so in California, each local health jurisdiction, there are 61, has a health officer who sets policy at their discretion. So if 5 health officers take the same stance on a gray area, do you think that could help them from legal challenges, and could there be strength in numbers?
This is Matthew. Music kind of depends on what position they take. Just because 5 do it doesn't mean it's a good idea. On the other hand, there is, I think, in law, and I think we find it in different ways that that standards for behavior or standards for activities, the things that are repeated, can be established by groups that are really external to the law. And sometimes those standards can be incorporated into attempts to hold people accountable. The one that comes to my mind is the idea of standards of care in medicine. Medical standards of care are not established by laws or lawyers or legislatures. They're established by physicians and nurses and others working in healthcare. And yet, those standards can become legal standards if they're incorporated into a lawsuit. So the idea that we establish some sort of standard way of doing something or standard way of looking at something by a group of people agreeing to it, I think there is precedent for that in the law. I don't know that it would apply to that situation in California with that number, but I think as a concept, we see that incorporated into some legal systems and legal doctrines.
Thanks, Matthew. And also thanks to Denise and to Lance. That's all the time we have for questions. yeah, thanks to everyone for dialing in and listening to today's webinar. So I'll turn it back over to our host.
Thanks so much, Jason, and I'd also like to thank all of our speakers today for their insights into today's topic, Lance, Denise, and Matthew. Thanks to everyone who submitted a question as well. If we didn't get a chance to answer yours, we will follow up with you via email if your question requires an answer. A few final notes. Today's webinar was recorded, and you'll be receiving an email with a link to access that recording when it's available, so check your inboxes for that. There's also a URL on your screen right now that you can visit to access the recording when it's ready. That's networkforphl.org/webinars. Now, that email you'll receive will also include a link to a brief survey that we hope you'll take. We'd really like to know your thoughts concerning today's webinar and what topics you'd be interested in for future webinars. We really do read all of your feedback, so please be sure to take a couple of moments to complete that survey. And finally, you'll also be receiving an email from ASLME with information about applying for CLE credit for this webinar. Thanks so much for being with us today. That does conclude today's webinar. Have a great day.